with there, then the teaching profession would not truly be a profession. And I ask the members and you, Minister, to bear that distinction in mind, even though there may be an overlap from time to time. Thank you.
Go ahead, Ms. Sherland.
This issue has, as the member had mentioned earlier, relates to clause 51, where the council will make an assessment when they receive a complaint to determine whether it is appropriate to either refer the complaint to the ministry for investigation, refer the complaint to the board, or to any other employer of the teacher. And so this clause was crafted to get away from what is being intimated here, where it is being said that it seems the minister can arbitrarily designate persons from the council to investigate a complaint. So there is a division or a distinction being made where it's not the same person who receives the complaint who will do the investigation. So I think 51 deals adequately with this concern, because when the complaint is received, and it's not the council that is going to investigate, it is somebody else. And at that point, having received the outcome of the investigation, then the council will later on do an inquiry. So I'm not sure how it is that we should address this concern. I don't know if there's a real concern here based on 51. When we were talking with the ministry, we can consider whether 51C, an amendment can be made there, because it says here, conduct an inquiry into the complaint. And we are trying to get away from the council doing the investigation. So perhaps C, there may be an amendment necessary at C.
But it is based on the clause.
Sorry, the member Brown had his hand up first. Sorry.
Thank you, Minister.
Yeah.
I share the views expressed by my Senate colleague, Graham, that there's a difference between a professional breach and a contractual breach. And there's a term that is often used in legislation for the avoidance of doubt. And maybe we should seek to incorporate a term like matters relating to contract would be dealt with by the school boards, and matters relating to professional conduct, breach of professional code or whatever, be dealt with through the council. So if we take that approach, we would meet the concerns of the JTA and others who have said, the church, I remember, was very strong on this, that we should relate to the employer-employee relationship in a different way than we deal with violating some code or ethics relating to the teaching profession. And so I share Ransford's approach to it and urge us to adapt that, in addition to inserting something for the avoidance of doubt. This is how it would operate. Thank you.
Member Hamilton? Answer? But also, let me ask then, if we're saying that we will retain this option for persons to go to the council and then the council to look at it and decide where it should go. I don't believe that we need to make a distinction between whether it's contractual or otherwise, right? Because if it's a contract issue, the council would have to send it back to the board, and the council can't take on contractual issues. And if it's otherwise, it sounds like they have the option to decide where it goes.
Yes, Minister, I'm wondering, is it that we want it, the A, B, and C to be so specific to say where it's a contractual matter, the council should direct the complaint to the board? Should we be going to that detail?
No, I don't think so. I don't think so.
Madam Chair, I agree with you. I don't think we need to go into that detail at all on that matter. Because the point you raised a while ago makes it seem as though it's not necessary at all.
Is it that, though, that they know their function, and so it's not necessary to put the detail in it? I think that is what I would want to...
You're talking about...
If it is that council? We're asking that question now, should we be so, strict as far as laying it out as to if it's contractual or not, this is where it goes, who handles that? If it is that we're asking that question, should we then not possibly look at that?
Senator, yes, sorry, Senator. You can go
just
ahead.
to respond to that, Minister, is that you are not going to find always the possibility to discreetly divide contractual and professional. There always and very often will be an overlap between the two. It may be that the council may decide to delay dealing with the matter until the board deals with it. But I'm assuring you that many professional matters will also be contractual. And I also want to raise the question, because I think one of the technical officers mentioned whether or not at I think it is 51, and the whole question of an investigation being done and the fact that the investigation is to be done by some other person apart from the council. And even that is useful in theory, but I would like us to say, if it is that you wish an investigation to be done, maybe you should empower the staff of the council to be able to carry out investigation. So you don't have the conflict between the council doing investigation and doing the hearing itself. And secondly, I think we also must make provision that somebody makes a complaint, provide the information, and the council immediately wishes to have a hearing. Why should they be forced to investigate everything? If Ransford Graham says that teacher A stole $1 and I have a video and everything ready and I'm ready to give evidence, why do you need an investigation in that? I think they should have the power to investigate if necessary, and where not necessary, they have their hearing and they make their decision. It's a matter for them. And the third thing, I think that the staff should be given specific powers to investigate so that they don't have to go outside to get an investigation, and at the same time preserving the separation of powers, because the council would then not be in the investigation. I ask the technical team to consider these matters.
Mr. Foreman, please go ahead.
Yes, good morning, everyone. I just wanted to contribute a few comments to this discussion. The first relates to the structure of Clause 51. My understanding of the rationale for this structure, and in particular subsection C, is that there may well be situations where, having received a complaint, the council considers that there's enough information there to allow them to undertake an inquiry, so that there would be no need to refer the matter to anybody else to investigate. So the example that Senator Braham just gave of somebody providing documentation, videos, or some hard evidence that would allow for some inquiry to take place immediately would be facilitated under C. Whereas with, for example, subsection B, I think it contemplates a situation where a bare bones complaint is made. A teacher did something wrong at a particular school. There's no additional information there, so the council deputizes the school to investigate the matter and then report to the council on the fruits of that investigation. And subsection A, as I recall, came about out of an interest in avoiding the type of natural justice concerns that arise whenever one entity is given the power to both investigate and adjudicate. So that the latter concern raised by Senator Braham, I think my recollection is that A came about to avoid a situation where the council itself is doing investigative work and then also doing adjudicative work. So that was the rationale, as I understand it, behind how this structure came about. So I wanted to add that for the deliberations.
Okay, so Mr. Foreman, are you saying that 51 should remain the way it is, or are you proposing any changes then to it?
At the risk of being accused of ducking your question, that ultimately will be a matter for the committee. I just wanted to provide some of the rationale behind how this clause came about. And I do recall that in some earlier stages, there was some thought of empowering the council itself to carry out investigations, and there was concerns about the natural justice aspects that might arise there. Whether there may be other options, for example, specifically designating a department within the council and setting that aside as a body that would be responsible for doing investigations if the council determines that an investigation ought to be carried out. Maybe it's something that requires some further consideration, and it's a matter that we here at the agency would need to consider a little bit before providing any firm view on it from a legal perspective.
Chair.
Senator Brown, ahead of you, sorry. Senator Brown.
Yes. It will appear to me, Chairman, that clause 50 is limited to matters, condition imposed on registrations, matters in relation to 10. Oh, sorry, let me start the video. My apologies. Matters related to conditions imposed on registration, which is what 50A1 says. 50A2 says clause 10. And 50A3 speaks to 34, clause 34. So it appeared to me that this is a limited role for the council in terms of the matters they may intervene on in terms of complaints coming to them. and 51 relates straight up to 50, so that we, again I'm saying, this appeared to me to be matters related to fit and proper, registration, and so this ought not to be dealing with the matters of discipline in general, contractual. And I just want to refer to the teachers, the Parent Teachers Association raised the issue of somebody in breach of a legal obligation or in breach of some laws abroad or even here. That is a matter that complaint could come under 50. But somebody being accused of absent from work, it's a different section. And so we need to reaffirm that the Education Act that addresses the disciplinary matters remain over there, and that this section 50 and the attendant clauses on it relates really to matters having to do with the condition of registration and clause 10 and clause 34. Otherwise, I think we're going to get into difficulty trying to get to other clause, get to other infractions under clause 50. So just to make it clear that this is limited. That's how I read it. It's a limited clause. Thank you.
Member Hamilton.
Thank you, Chair. I do agree with Senator Brown's observation just now that the council is really limited as to what it is it can investigate based on the Act. I also do recall as well the consideration to include convictions within Section 50. I think it would have been 50A5. We had agreed that we would include that as one of those complaints that can be made to the council. And I also do agree that we should possibly consider referring to a disciplinary committee of the council, identifying that within the legislation so that it is clear that the council will have a separate body to treat with these kinds of complaints.
Madam Chair, I would like to make a recommendation. The fact that we're talking so much about this right now means that there's a little gap somewhere. And I would like to suggest, and I think that's what Member Cuthbert was referring to earlier, but I'd like to suggest if it could be pulled for us, whether by the committee clerk or the legal team, I'm not sure whom, pull the different sections that are in the legislation, the bill relating to this matter. And if we can just look at it, because right now we're flipping from page to page while having the discussion. But what the JTA is saying is there are sections of the bill where complaints are referred to the ministry. There are sections where things are referred to the board. Plus, as Member Brown stated, disciplinary action is in the, what's it called, the original bill, the Education Act. If we can pull all the pieces and then we can look at it together, because it's very difficult for us to have this conversation when things are in different spaces. Because right now we're talking off the top of our head, but most of us don't have the Education Act in front of us and can relate it to that as well. So is that a possibility, Madam Chair?
Chair, no, I'll yield.
Go ahead, legal, yeah.
Thank you, Chair. Good morning, everyone. I wanted to also support what Member Brown was saying earlier. I was signaling to you, Chair, to make that clarification that Section 51, as it relates to referral of complaint, is limited to Section 50, where it's only under particular circumstances where those complaints will be assessed. And it says at clause 51 that upon receipt of a complaint under section 50, so it's not any complaint, so the matter of discipline in terms of, for example, neglect of duty, inefficiency, irregular attendance, all of those things that are still existing under section 55 of the education regulation will still be treated at the board level. So we just wanted to make that clarification. Thank you.
That's it, Chair.
Senator Bryan.
What would have happened is that the JTA, in looking at it, spoke of disciplining, and they wanted to be very clear that matters contained with the rules of the school, the operations of a teacher, the conduct of a teacher is dealt with at a different level at the school board. And there is no interference of the council itself in treating with these matters. Senator Brown indicated that, 51 is limited. I would want to propose that it is confined to what is related into 50.
Senator Braham, Member Braham, you wanted to come in again?
Sorry about that. I want to say that I find myself in some disagreement with Member Gale, because the section speaks for itself. It says in relation to these issues, a person may make a complaint. But if you go and put in a section to say that matters of contract and teacher behavior on the job is for the school board, you may find that it is denying the council power to deal with matters that fall under 51 that overlap with contractual issues. I do not think that we should have any such limitation apart than what is there already. The limitation that is there already allows the council to deal with disciplinary matters, even if those disciplinary matters end up to also be matters that could arise under contract or under the purview. The important thing is that they must also fall under section 50 of the Act. If you go and put it otherwise, then the matters that fall under 50, but may well also overlap, will end up not being treated by the council. And I don't agree with that. The second point I want to make is that, and maybe Mr. Foreman could answer this, from my look of the matter, the council is not permitted to on its own volition, and I could be wrong. So if I am wrong, I'm going to ask somebody to identify, to initiate a process in this matter. And I don't think that is wise. For example, the General Legal Counsel allow a member of the council, not the council itself, to lay a complaint. And I think that is a very useful authority, because the council may receive information that members of the public don't have. And if I'm right, then it would mean that they would have to go behind the scenes and speak to Graham and ask Graham to make a complaint. And I don't think that would be appropriate. So I think that at least a member of the council should be entitled, or maybe the chief executive officer of the council, when so directed, to raise a complaint either to the disciplinary committee or to the council, independently of somebody referring something to the council. So the 2 points I make is that I don't agree with the additional limitation being proposed by my friend Mr. Gale, and I think that council ought to have the power in one way or the other where it may be able to initiate complaints.
But Member Braham, I wasn't proposing any additional insertion, You may have misunderstood. What I was simply saying is that the areas under 51 is already confined, are specific to 50. and that matters dealing with discipline of breach of internal rules are dealt with at the level of the institution through the board. So there may have been a misinterpretation of what I said in your ears.
Very well, sir.
Could I also add that, through your chair, that there's nothing preventing a member of council now from lodging a report. 50 says a person who alleges that. So a person could be a member of council. So it does not change that, Ronnie, in my view. But the key thing is the limitation that is already there in 50. And that binds the rest of action that flows under this section. So it will appear to me that the matters of discipline, even if it comes to the professional standard, once it doesn't fit into A, 50A, it goes to the normal, as I think it's Senator Rodriguez Campbell said, or Campbell Rodriguez says, it goes to the disciplinary committee under the Education Act. So I think it covers, oh, sorry. I think it covers that, so that the disciplinary, in other words, what we're saying is that this bill is not revoking the authority and power of the HR committees or disciplinary committees of the schools. And I believe it's usually what it's called, the HR committees. So it's not revoking those powers. And we can simply insert some which says, for the avoidance of doubt, the powers contained in the education. Sorry?
I disagree with that. There's no need to put in anything about avoidance of doubt. If you do that, it's going to be treated as a further limiting factor.
Minister, I think also, Minister, I'm here. Chair, sorry. I think what is happening, I go back to the point, a lot of us don't know what's in the Education Act. So we're talking around the issue because we're not aware of what exists there. We're only seeing what is in here. So I don't know if they could just print a page, that page out of the Act and just give to us now. Because you notice the reference keeps going back to what we think is missing, but it exists in the Education Act.
So, member, I'll call on our legal counsel, who is the ministry's legal counsel, to explain that particular part of the Education Act.
Thank you, Chair. It's actually the Education Regulations, Regulation 55. Which states that a teacher in a public educational institution may have disciplinary action taken against him for A, improper conduct while in school, B, neglect of duty, C, inefficiency, D, irregular attendance, E, persistent unpunctuality, F, lack of discipline, and G, such other conduct as may amount to professional misconduct. That's what the provision reads. But I think the difficulty we're having is not appreciating properly what Section 50 states, or it really limits the type of complaint that can be made by a person. It's really limited to, as Member Brown would have alluded to initially, they have failed to comply with a condition imposed on registration as a teacher, or on the license or authorization to teach, or if they have contravened any professional standards referred to in Section 10, or if they are not fit and proper to teach in accordance with Section 34, or they have as contravened or failed to comply with a provision of the Act itself. And it also provides for the equivalent of the registration or license of a teacher, or the authorization to teach of an instructor, has been suspended or revoked by an overseas regulatory authority. So it's very specific as to the type of complaint that a person can make under Section 50 to the council. Maybe it might be an understanding that a person might end up making a complaint to the council outside of these limitations. Or the issue is when the council receives that complaint, how is it treated with? That is the matter to be determined, how that complaint will be treated with. And I guess the council might just indicate to that individual to refer the matter to the board, so that the board can make the complaint to the personnel committee of the school. Thank you.
Thank you. Let me just pause for a moment to recognize students who are here today. We have students and teachers. We have students from Snowdon Primary School in Manchester with their teachers, and you are watching the proceedings of the Joint Select Committee with regards to the Teaching Council Act 2022. We're in discussion of that today. Thank you for coming, and I hope that we will give you plenty today that you could take back to your classes. Okay. So I have a question. What I'm still not getting is if we should be including in here, as was suggested, the ability to empower the staff to carry out an investigation, whether or not the council should be permitted on its own volition to institute a process, and whether or not there should be included a disciplinary committee at the council.
Madam Chair.
Member Gale?
Oh. Go ahead, Madam.
Oh, go ahead, Member Rodriguez. Yes.
Chair, I don't think we need to do that. And the way it is written now in 50, I'm just trying to see. No, so of course I got the regulations that we referred to. So that's taken care of in the Education Act. That's fine. 50 here is very clear and very specific as to what it seeks to do. So I don't think we need to do anything there. In terms of whether or not we need a disciplinary committee, I don't think so, because the bill further around speaks to if the teacher feels that they have been wronged by the process that exists, there's an appeals committee that is established, that is to be established by the council. I just can't remember the section, if one of the legal persons can remind me. So that is there if what exists does not work. Or am I misunderstanding?
I think when you're dealing with appeals, it's a bit different. So appeals is the next level of the substantive issue.
Yes.
Now, why a disciplinary committee may be relevant is that it provides that independence that is required from the council when you're dealing with disciplinary actions.
But so that exists already.
No, it is not explicitly stated.
No, I'm saying, and that is why I'm saying we should have had the Education Act to look at in this.
No, so the Education Act, I would imagine, would speak separately from this particular body. So this body will have its own disciplinary committee, which is what I'm thinking we should establish within the legislation.
So I'm not clear of my own mind, and maybe this is where my issue lies. Why do we have a disciplinary committee at the board level and one at the council level?
Because at the board level, you're dealing with different issues.
Okay.
You're dealing with school issues. Anastasia, if we can read the list again of things. Teachers who are late, continually, habitually late. teachers who do other things.
But of the other matters in, okay.
Yeah.
So I'm in support of it then.
Yeah,
okay.
What is not clear? So you have the situation where you know who conducts the investigation, but you have an area speaking to a disciplinary inquiry. Now, who conducts that disciplinary inquiry? And so you must determine and define the committee that is going to conduct that inquiry, which is a separate and distinct instrument or authority. And that must be defined. And once that is defined, that is now speaking to what the JTA would have claimed in that it does not distinctly provide for the creation of a disciplinary committee. So it would be clear to us if we can make that determination within this process. The other thing I want to make reference to is that in 50, as we have agreed that it is confined or specific or what's the other term that was used? In that if there's a complaint made outside of these specific areas that are so defined, then the council can determine what to do. In other words, you get a complaint that is not specific to this, you have to send it back to where it came from. Because this is very clear in terms of what the allegations are, the infractions are, the breaches are.
Mr. Foreman?
Yes, thank you, Chair. I just wanted to make a recommendation, given where the discussion has gone thus far. I think you accurately summarized some of the issues that have come up in referring to the question of whether there should be a separate disciplinary committee, whether the council should be able to make complaints, whether the council should also have staff to do investigations, and so on. Those proposals, I think, might require some consideration internally. And on that footing, I might recommend to the committee that the technical staff be given an opportunity to reflect on it and perhaps make some recommendations for consideration. And I say that because if any one of these proposals are endorsed by the committee, it may well require some reworking of aspects of the legislation. So that's one thing. The second thing I'd just like to say, in relation to the JTA's comments, part of the concern that I understand them to be making as well is that there may be situations where, for example, the school initiates some sort of disciplinary action against a teacher, and let's say a complaint is also made to the council at the same time in relation to that same matter, and the issue falls into one of those areas where there's overlap between the contractual obligations and the professional obligations. I don't know, for example, a teacher gets into a fight. I would imagine that would concern both the school at a contract level and the professional standing of the teacher at the level of the teaching council. I understand the JTA to be saying that if one set of disciplinary proceedings is initiated against a teacher, then that teacher should not be made to be fighting two sets of proceedings at the same time. Right? So if the council starts investigating, maybe the school should stop, or if the school is investigating, the council should stop. And that's a matter that the committee hasn't yet, I think, fully considered. Or put differently, if the decision is to have the provisions as they are, some consideration should be given to whether or not that potential will remain, or if, for example, the bill will preclude or require that one set of proceedings be stayed while another is being done, or something along those lines. Thank you.
Thank you, Mr. Foreman. We'll take on board your suggestion to allow the technical persons to consider all the deliberations with regards to this particular issue this morning before we make any decision. But I know that Member Braham may want to have a last word on this.
Yes. 2 points, Chairman. The question of not having 2 investigations going at the same time, I understand that it can be a problem in the sense that it could be a bit oppressive. However, we have to be very careful, because if there is a school board inquiry, there is that sometimes is an indefinite process. So I think that probably the better way to deal with that is to give the council the power to stay their hand if it is appropriate. And they can stay their hand if they chose to do so. But I certainly would not want to see a situation where the council is boxed out because there is something happening at the school board, because then the matter then would depend on the efficiency of that particular school board. If it is not efficient, then it could be an indefinite process. And the second point, I am of the view that somehow or the other, an arm of the council, whether it is a member of council, whether it is a staff of council, should be given the independent authority to lay a complaint. I do not think that because Section 50 refers to a person, it is sufficient to enable a member of council to lay a complaint. If we don't do that, it is going to create a significant gap that would not have been covered. Thank you, Minister.
All right, thank you. Go ahead, Ms. Gordon-Jones.
Thank you, Chair. Just to clarify a point that was indicated by a member just now, in terms of matters being treated by the board has a period of 9 months within which to dispense with the treatment of that matter. So there is actually a limitation. So it cannot be an indefinite treatment of matters that come before the board. The time will lapse if it is that 9 months has passed and the matter is not treated with. But I just wanted to indicate, Minister.
But what happens to the matter, though?
Pardon?
What happens to the matter if 9 months has lapsed?
Well, based on regulations, it cannot be dealt with by the board again.
You know that that's a dead end, right?
Yes, Minister, it is, and that is why we are also trying to, in reviewing the education regulations, that's an issue that will be treated with at that stage in terms of that 9-month period that is now stated within the regulations. In relation to the committee, the disciplinary committee, under the first schedule, just want to indicate that 14.2, 2B in particular, indicates that the board shall, with the approval of the minister, constitute standing committees which specify terms of reference and membership, including, and I go down to B, the professional practice and conduct committee, which shall be responsible for disciplinary matters relating to teachers. So that is the disciplinary committee under the Act that will treat with complaints under the Act. It's 14 under the first schedule, paragraph 14, 2B, page 66. Thank you.
Chairman?
Go ahead, member.
It's essentially, I agree with the recommendation of Mr. Foreman. I think it's important that this bill, clauses 50 to 71, deals with the issue of how you're going to treat complaints. So it will be useful for the technical people to look at it and come back to us. I also appreciate the point he made about double jeopardy. And I wish to say that the public service regulations have a way of dealing with this. It says same facts. You can bring in back the same facts, charging under the same facts and circumstances. So there is, in my view, a need to look at how the Public Services Commission deals with what essentially is double jeopardy and see if we need to insert those wordings in this legislation as well. But Ronnie, they wrote to LSP with good intention. You put a 9-month limitation. I wish they had that in other areas, because I just finished a case where the man was dismissed 6 years ago. I'm sure we don't want to have our teachers waiting that long. So we need some control. But as I say, I support Mr. Foreman's call for looking back at the matter, and also there legislation that addresses the issue of double jeopardy. Public service regulation is one such, and maybe we should see if we need to incorporate it. Thank you.
All right, thank you, members. Again, we will allow our technical persons, experts, to take a look at this, given how much of a discussion there was with regards to this particular issue this morning, and come back to us, consider all the various issues that have come up, whether we give the council the power to stay their hand, whether we include the disciplinary committee, but you're saying that that's already allowed for, that the council should be permitted on its own volition to institute a process. The council should have the power to lay a complaint, and so on. All these different suggestions, recommendations. I would like for you to take those back and let us know after some consideration. If they're already provided for, wherever they're provided for, and if not, how can they be included, provided for, if we agree in this bill?
Madam Chair, can I ask a question of Mrs. Sherland? In your earlier statement, I have when you spoke earlier, when we just began this conversation, you said that maybe 51C would need to be revisited. What did you have in mind? Why you suggested that 51C may need to be?
Well, there was a discussion because A and B says refer a complaint to the ministry, refer a complaint to the board, and then C, in essence, jumps to an inquiry.
Right.
So there was a discussion as to whether C should really say refer a complaint to a committee of the council. And we were not sure if that would be appropriate. But the idea was that C is somewhat different from A and B, because you're referring the complaint, you're not going straight to the inquiry, as in C. So, we were wondering, is it appropriate for the council on receiving the complaint to go straight to an inquiry?
And the R in B would suggest that. When you look at the R in B, it would suggest that.
Sorry, member.
So if B says refer the complaint to the board of the relevant educational institution or the other employer of the licensed teacher or instructor, as the case may be, for investigation, or conduct an inquiry into the complaint pursuant to Section 53. Now, who conducts the inquiry?
But before we get to who conducts the inquiry, we need to, because it says the council shall. Schedule 1. Yes. But does the or make it okay? Because I'm thinking with the or, that's Senator Gale, which is why I brought it back up, because I was curious as well as to what you were thinking.
No, it doesn't, the or doesn't make it okay, so to speak, because the or is just indicating the various options that the council has when they receive a complaint.
And the council at 51D-C can conduct an inquiry. That's what it says. Upon receipt of a complaint under Section 50, the council shall, and C, conduct an inquiry. So that the
pursuant to 53, Member Braham, pursuant to 53.
Yes, and 53 says the following procedure shall apply in relation to an inquiry conducted by the council. So at the moment, it is very clear that it is intent on this present draft that the council is the one doing the conducting of the inquiry.
Are we saying then that based on what's in Schedule 1, where there is actually a disciplinary committee, C should be reworded to reflect that it goes to not the entire council, but to the disciplinary committee of the council?
That is a matter that the technical people will advise. But as presently structured, I don't think that that committee in the schedule can be treated as a disciplinary committee. The disciplinary function is clearly and expressly given to the council.
So I'm going to ask our legal experts to consider, right, all of the conversation here this morning, the various recommendations, questions, and to come back to us on this particular issue.
Chair, this is Nadine Wilkins from the LRD. I hear that what you've said about examining it so that we can move on, but I just wanted to make one point that 51 seemed to be in conflict with 54, because 54 is saying that when the ministry or the board of the institution or whoever does an investigation, then the board may conduct an inquiry in any information. So I'm just thinking that perhaps there is some disconnect in the provisions between 51 and 54. Because one is saying they shall conduct the inquiry, but when you go down further, they may conduct an inquiry.
I would imagine that the wording is dependent on what the investigation reveals. So if the investigation reveals that there's nothing to have an inquiry on, it can't be a shall. It must be a may.
Yes, but then 53 does not provide for the inquiry conducted by the council. 53 is talking about the person designated by the ministry, the board of the institution, the employer, and that person submitting a report to the council. So everything after that is flowing from that.
So it says at 53, upon completing an investigation pursuant to the referral of a complaint under Section 51, the person designated by the ministry under Section 51, the board of the relevant educational institution, or the employer of the licensed teacher or instructor shall submit a report to the council of the findings of the investigations.
Yes, member, that's my point. It doesn't make any reference to the council itself conducting an inquiry, which is at 51C. It only provides for the report coming from the other entities.
Because there was no reference prior to now of the council doing an investigation.
Yes, 51C is saying that the council shall conduct, it's an option they have, and it's a shall conduct.
51C says the council shall conduct an inquiry, not an investigation.
Yes. Okay, so maybe what we need to rationalize is the difference between an inquiry and an investigation.
It's two separate, I see it as two separate functions.
But maybe that is something else that needs to be resolved.
So I believe, I may be wrong, but from my understanding is that if somebody makes a complaint and it requires an investigation, 51A and B gives you the option as to how the investigation will take place. Now, if it is that the complaint does not necessarily require investigation, then C now would take precedence. So C would allow the council to just go ahead with an inquiry. That's how I see it.
Yes,
Chair.
but is that okay?
Go ahead. Go ahead. Go ahead, Nadine.
Through you, Chair, just to say that is where the problem is. By right, 51 should really be dealing with investigations alone. And then after the outcome of an investigation, then the inquiry possibly happens. So that is why C is perhaps a problem. But can it be resolved by saying a committee of the council does the investigation? So you have a separation between an inquiry by one entity and the investigation by one entity, and then an inquiry by another entity. So that it cannot be said that one entity is the judge and jury in the matter.
That's the important point, because in the scheme of things, first of all, there's an allegation. Now, the allegation must be first investigated, and we must define who those investigators are. Upon the investigation is supposed to ascertain the facts surrounding the allegation, and then there ought to be a determination if you move now to an inquiry, and who is going to conduct that inquiry. So when Mr. Foreman went ahead and to suggest that we must streamline the process, that's very important, because we do, for the abundance of caution, we don't want a situation where, as Mrs. Sherland indicated, you have the result of some component of it being the judge, jury, and executioner, right? So we have to streamline the process and clarify. And when you look at it, I don't think so.
No, because
C
is an anomaly.
Because C is calling for an inquiry,
and it doesn't belong in that section.
In the first instance.
No, it never says if. It says or. It says one or the other. No, it says or, so you can actually skip B because it's an or. So can we probably just ask them to rewrite it as Minister was suggesting? Just review the issue based on all the discussions and then bring it back to us. I don't know if you know what Minister was saying earlier.
Yes. That's what I'd like to ask, because I don't think we're going to work it out in this forum right now. And so we're asking for your technical expertise, your legal expertise, just to look at it. You've seen other legislation, how they lay out issues like this, and we can come back to this. All right. Member Brown, I'll give you the last word on this topic.
Yeah, Minister, I share the view which says Mr. Foreman's suggestion is appropriate here, and I concur. I really think we should step back a little, let them look at it based on the deliberations we have had thus far, and to see whether or not we need how we treat the issue of complaint to investigation to inquiry into a decision. So I share the view that we should step back a little bit and allow for the technical people to advise us and to make some options, including Ransford's points about whether or not we should insert disciplinary our powers to make a complaint into the council. I'm open to look at all the options. Thank you.
All right, thank you very much, Member. We're going to move on to the second general recommendation, and this time this one would be from the University of the West Indies School of Education. And it says the layout of the bill is incomplete, given that it does not have a table of content, typically called in this context, arrangement of sections. It may be assumed that a critical navigational guide is omitted because it is a bill and may not yet an act. However, that assumption would be unsafe, as recently enacted law acts that do not have the arrangement of sections. Stakeholders therefore recommend that the omission should be highlighted on behalf of the School of Education. And I think the response from our technical persons is that the arrangement of section is part of the draft bill and is updated accordingly. So I think we can accept that and move on. Yeah. So we'll accept that and move on.
I actually, Minister, sorry to be that person today, but I didn't understand the response.
The response is that they will update it
Minister
accordingly, or maybe we hear from Ms. Sherlin, if you could just explain what the School of Education was getting at and what has been done to...
No, Minister, not what the School of Education was asking, because it was a question I had asked before, and I was told it's just so some bills are sent with the table of contents and some aren't. No, but there are other draft bills where we get a table of contents. So that's what I was trying to figure out. If the response under it, that it will be updated, is what you're saying. That was my question. Oh, there is one. So you see, it's a different thing. That. So I'm not sure.
Go ahead, Ms. Sherlin or Ms. Gordon.
Arrangement of sections was provided. I'm not sure why. Well, I'm told that it was printed, but perhaps not everybody got the copy. I'm not sure why. I'm not sure.
All right, so we will accept that the arrangement of sections will be part of the bill, and and it will be updated accordingly. All right, we'll move on to the next general recommendation from the University of Technology. It says we question whether the overlapping roles of oversight and regulatory body would constitute a conflict of interest. We suggest that good governance practice suggests that central oversight bodies like the Jamaica Teaching Council are not effective if they are independent of regulatory bodies and service provision entities. And the response here is that we're not in agreement. Small states do not accommodate such separation. No conflict of interest will arise. Any further comments on this, Ms. Sherlin or Ms. Anastasia? Okay. Dr. Gordon.
Thank you, Minister. Good morning, everyone. Both agencies are distinctly different, with different functions. The University Council of Jamaica is an accrediting body, and the Jamaica Teaching Council is a governance body for the profession and does not accredit programs. So the agencies are distinctly different. Thank you.
All right, we'll move on to the next general recommendation from the National Parent Teachers Association of Jamaica. And this is a recommendation regarding penalties. They believe that the fine of $500,000 is too low to act as any form of deterrent, and this should be raised to at least $2.5 million. But I recall, though, that there were other entities that spoke to, right? And probably we should all put them together. Right, because there were other recommendations about tiering and, yeah, and I think, yeah, I know, it's a little bit...
I was of the opinion that the matrix would have consolidated the issues per clause so that we could deal with each clause and each proposal at the same time. How we're doing it now, we'll have to be doubling back. Yeah.
Chairman.
Please go ahead.
Yeah, I understand that the matter of fine has a specific clause, and that the matrix attempted to put general issues before we get to clause by clause. And I'd recommend that the issue of the fine be dealt with when we come to that specific clause dealing with the penalties down there. So it ought not to detain us at this moment. I'm not sure, however, I'm satisfied with the response to the University of Technology, but I'm not going to raise more on that now, because clearly we'll come back to it when we come to some of the specific clause. So, but I don't think we need to detain ourselves on the fees and the fines right now, because there's a specific clause to deal with. It's not a general policy matter. I share the view of Member Hamilton.
Yes, I agree that we wait for the specific clause on this. All right, we'll continue to take the general recommendations. Another one here from the Jamaica Teachers Association. The bill does not prohibit the transferability and assignability of license or grants. This, in our view, must be added. Similar provisions can be found in other legislation concerning licenses, such as Banking Services Act. And the response is that the provision can be inserted to provide for this issue. And I guess when we get to clause 44, is that what it's saying? Or a new 45, huh?
What was that issue of the transferability of licensure? Who would a teacher transfer the license to? Or, I'm trying to remember what that issue was.
But it's saying that the bill does not explicitly prohibit it, and they would like for it to be included.
Ah, okay.
Yes. And the response is that the provision can be inserted to provide for this issue. When we get to, they think there could be a new clause 45.
Minister?
Yes, go ahead, member.
I was listening carefully to the question raised by Member Hamilton, because I don't understand what is the mischief we are trying to fix. I can't imagine how the license could be transferred. So if the committee could explain to me, by putting in a clause preventing the transfer of license, what is it that we are trying to fix? I don't understand, I must confess. Because I can't see how it can be transferred to anybody. Did you hear that, Minister?
I got that, member. Any response? But is it that someone could say, well, the act or the regulation doesn't say it can't be transferred, so it can be?
So I could give it to my son, Minister, is that it? I don't understand what is it that we are trying to fix. I mean, I'm really sincerely, because I can't give the license to my son or my daughter.
You don't need a clause for something that's a non-issue, actually, because you cannot transfer your teaching license. There's no scenario where you can. The only thing that my mind came up with, and it's such a long shot, is you paid for the year, and so maybe, and you leave after 2 months, maybe the next 10 months, the money, it's just not an issue.
Well,
so
I don't know if it's not an issue. I just wanted to be explained why, because there may be an issue that I haven't thought about.
No. So we can't put something in there to say we can't transfer, or you're not able to transfer because you can't transfer. Who could you possibly transfer to?
Well, let me ask our legal persons, because their response was that this provision can be provided for, just to give some context around it as to what the thinking was.
Sorry, what would have been the thought, though, in making the provision for an insertion of a new 45? What would have been the thought in proposing an insertion to provide on this issue with a new 45? So it would be an addition to clause 45, but what would have been the thought?
I believe it's a provision which we have in other pieces of legislation. And, well, the opinion now is that it's not applicable here. But it would say something like a license or authorization to teach is not transferable or assignable, full stop.
And I don't see any harm in putting that in the bill.
So, Minister, that would apply only if the license says you are licensed to teach at Gainstead only, but if the license is broad in its construction to allow you to teach in this education system of Jamaica, then there's no question of transfer or such. So only the license limited to location that you'd want to transfer from location A to location B. And I don't think that's how you're going to draft the licensing arrangement.
But in terms of context, so if you transfer a license for an organization or a company, that is understood. But for a professional individual, I am not seeing where that any such license could be transferred. And if they spoke to the Banking Services Act, in context, it might be for an institution to be able to transfer the license if the institution changes or if there's a merger or a takeover. But for a professional individual, I'm not seeing where that can take place. So I'm not supporting it.
Go ahead, Ms. Gordon-Jones.
Thanks, Chair. Based on the discussion, we will agree to not insert that provision.
All right, we will move on to the next general recommendation. The metric used to determine has the English language skills in this subsection. I move it under University of the West Indies School of Education. I am not so clear on what's written here.
What subsection are they referring to, Minister? Do you
go to the column, mark University of the West Indies.
Yes, but they're saying has the English language skills in this subsection. What subsection?
Not sure. Not sure. I'll go on microphone, please.
I'm thinking maybe it's under the qualification of a teacher, if I recall.
Yes, clause 27 is one. 27C.
Right.
Are we're going to be discussing that particular clause specifically?
And 29F, Chair.
Okay, so we'll move it to that. It's not a general recommendation, so we'll move this to clause 29, 27 and 29. You said 27. Okay.
That seems quite fine to me, the requirement, but I suppose we will see what it is that they'd like to do with the English language.
Not sure I heard you clearly.
No, not at all, Minister. No, I will reserve it until the time comes.
Chair?
Yes.
Just to indicate that currently on the matrix, it does not indicate that that issue is up for discussion, so we would have to make note of it whenever we reach clause 27, that comment needs to be discussed.
All right, we'll move to the next one under the University of Technology, but that relates to professional standards that it sounds like we need to go into the clause to discuss that as well. Yeah. I think for all the general recommendations, we have to, they all link to, yeah, they're all specific, and I think we should map them to the particular clause to which they relate so that we can, have them grouped and have one discussion.
Just to bear in mind, Chair, that there would have been some recommendations made that weren't specific to any clause, but the respondents wanted to insert recommendations. So those have to be treated differently. So let's not be searching for a particular clause that don't exist to align them to. Because there were some...
Yeah, but in all of these so far, they are aligned to a particular clause.
Madam Chair,
yes.
Maybe the committee clerk, sorry he's not here. I think this is his first rodeo, so we, bear with him a little bit. But if he could just go back and take them from general recommendations and put them in the relevant sections, it will help us for our next meeting to have it, so we could start at the beginning, clause by clause, versus these general recommendations, which are not general.
Good morning here. Good morning, Chair. Just to note, when you look at, just to help out my friend here, the clerk, a lot of these recommendations in the actual submissions themselves were not tied to clauses when he was preparing the matrix. So he may have had a difficulty or may have a difficulty he wouldn't have been aware of where these general recommendations as they appear in the submissions to go into the clause. So we may do some consultation so that he can get some mapping, but without more, if they would have appeared general in the substantive submissions, they would have been put general. And then where specific recommendations tied to clauses were made, then when we flip around, you will see that you start seeing the specific recommendations by clause. So for the next meeting, we'll try to get a list of any deferred recommendations that were made today so that we'll have them going forward when we're going clause by clause. And he can get some assistance from our friends and just ensure if there's any clauses that are not tied, we can just do that going forward. So for the next meeting, any of these clauses that do not in fact appear to be general, we'll put them where they need to be.
All right, so you'll work with you will work with them, or legal professionals, to sort it out so that we have a better flow to the conversation, and we have a sense that we're starting from the top and working our way through rather than circling back. We might miss something when we try to circle back. So members, given that, I don't think it makes sense to continue here today, unless you see a general one? All right, let's go to that.
Under the recommendation you just spoke of, in terms of the metrics, underneath that, the University of the West Indies, they had recommended that the bill address registration of and licensing of caregivers. So that would be a general recommendation that we can address now.
All right, let's pick up that one. It was recommended that the bill should address the registration and licensing of caregivers in nurseries and daycare centers, as many persons employed or engaged in teaching in early childhood institutions will not will not be fit to teach by virtue of their qualification. The response is that caregivers will be in a database. They have to satisfy the requirements of the Early Childhood Commission, and that this will be a collaborative effort between JTC with the Early Childhood Commission. So Dr. Gordon, can you expand on that a bit?
Thank you, Minister. The caregivers and various categories of early childhood persons, I must say they're not teachers, they're not trained teachers, but they work in the early childhood program. Those categories are in the commission, the Early Childhood Commission, and they're accepted as persons that should be in the classrooms with the children. And so we are in collaboration with the commission to set standards for them and what kind of authorization that they will have to be in the classroom. But we have to work with the commission.
Clarify.
Would that be stated in the bill or someplace? So there would be a link.
Chair.
If I may, Chair. There's a Schedule 2 that lists support persons to teachers. And what we have done is include the early childhood group in that schedule, so that they can be considered within the context of the bill.
Member?
So we spoke about the informal sector. And so you would have nurseries and daycare centers that are registered. But a house up the street that decides that they want to have a nursery or a daycare center, are we going to include them or capture them under this database?
They would have to be registered with the Early Childhood Commission, and they are now actively pursuing registration of our nurseries.
Okay.
Minister, Early Childhood Commission has a process of registration and licensing of daycare and nurseries and daycare centers. Yeah.
Minister?
Go ahead.
I need Wilkins again.
I'm sorry, please go ahead.
Camera off now. Yes, it's me. I think the difficulty is that they...
Can you position your camera better? Sorry, we're only seeing your head top. Okay. Yes, wonderful.
Is that better?
Thank you. Yes.
Clause 4 says that the Act applies to early childhood institutions. So I think the difficulty is that as we go through, there's no separation in the provisions when we're talking about the people who need to be licensed and all the regulatory provisions. We're not separating a person who teaches in an early childhood institution. So I'm thinking that that is why this issue is being flagged. So it is something that should be looked at as we go through whether the enjoining of the ECC ought to be provided for. So it is clear whose jurisdiction will apply when you're dealing with the early childhood institutions.
Madam Chair, can I ask a question of your support team? Because in my mind, this early childhood institutions were basic and infant schools, not nurseries. I don't know if I'm correct, because
that include that's there.
So I don't think nurseries would be included in early childhood institutions.
They're included.
They are
it's
included.
Early childhood nurseries. We call them what do you call? No, these are nurseries and daycare centers.
So they're included in early childhood institutions? Oh, okay.
So Chair, are we removing the early childhood institutions from this legislation and keeping it strictly within ECC? Or
are we just taking out, Member Hamilton, because remember early childhood include basic and infant schools. So
ECC doesn't cover the infant schools? So
ECC covers
it's economic.
Nurseries, basic school, infant schools, brain builder centers.
And they already have their standards?
Yes.
So maybe we can remove the early childhood institutions from this legislation and try to boost the ECC.
No, but I don't think, I think what we should do is separate for this legislation, a counter suggestion, Member Hamilton, for this legislation, separate basic and infant schools from nurseries. The reason I'm suggesting we do it that way is in nurseries, we're not teaching. The children are supposed to be playing and splashing. But in early childhood, in basic school, they're learning. They're supposed to be taught by professionals. So if you put the two together, it's two different categories, because a caregiver in a nursery is not a teacher. It's a caregiver. But the person in the basic school is a teacher. I stand to be corrected. So for this purpose, we should be dealing with the basic schools, but not the nurseries. Leave the nurseries to ECC. No, because basic school children don't need trained teachers. They need caregivers. The nurseries, need caregivers.
Just to be clear on definitions, well, you have nurseries, right, for babies, right? And then you have basic school, but by definition, those are considered to be offered by a private person. And then you have infant schools, which is government run and funded, but you also have brain builder centers, which would be the what do you call it now? The nurseries, right? Or daycare center, daycare center.
Well, the act actually speaks to teachers. It says the person who teaches. Now, in the early childhood program, there are categories of teachers that are not considered trained teachers under the Act. You have trained teachers in early childhood program. And then there are some categories of teachers trained by heart. They are considered, quote unquote, they carry out the act of teaching in the basic schools. Now, those categories of teachers will be considered under authorization to teach, because they have already been given some training that permit them to teach in the basic school or early childhood program. You can't deny them at this stage. Yeah? So we have to accommodate them. But we are talking about those that teach, not the caregivers. And yes, they're teachers, or they teach.
Madam Chair, so on page 8, clause 4(a), I think we need to, the legal team need to then reword 4(1)(a).
Just for clarity.
I'm trying to see.
In the Early Childhood Act,
Which section?
the definition of early childhood institution means a setting that provides developmentally appropriate care, stimulation, education, and socialization for children under the age of 6 years, including daycare centers and basic schools. So for us to use the term early childhood institution, it would mean this.
Would mean the person who teaches. Remember, the school system has other persons with support staff that we put in the schedule too. At this level, early childhood level, we're speaking to the person who teaches. And that's clear. It's a person who is teaching in an early childhood education.
And daycare centers.
Institution, yes. Wherever the person is teaching.
I'm worried about that because you're clear on it because you're part of the policy making. But Miss Jane could interpret that and she could be correct. And I don't know if it does any harm to just reword that little area so that we're specific, that we're not talking to about the people in the nurseries. I'm just saying it's a little bit based on the definitions on page 3 at the bottom for early childhood institutions. Because if we're saying the early childhood institution includes the nurseries, and then on page 8 for clause 4(1)(a), a person who teaches, someone in a nursery could say, with a 2-year-old could say that they're teaching. It could be accused by a parent that they are teaching.
But remember, the person who teaches has a specific definition in this act. If you look at page 6, teach means, and it goes through exactly what teach means.
Madam Chairman, perhaps for a little bit of clarity, that same point that you just made, we could look at the definition of teach, and the proposal is to in relation to paragraph A of the definition of teach, we would move some words to paragraph B so that paragraph A3, the services specified in the schedule, the persons who provide those services are not considered to be teachers, and so we would put that in B, would move A3 to B, to say does not include duties of the kind undertaken by the service, undertaken by a person who provides the services specified in the second schedule. And therefore, social services or the services provided by the caregivers in an early childhood education center would not fall.
That would help. Yeah. That would definitely help.
I share that view as well.
Are you suggesting to insert a new 4 and replace 4 with 5? Right.
Any other questions on that, or any other observations on that particular point? All right. Are there any
and
other...
just to indicate, seeing that we're on that section, at A3, it says the services specified in the second schedule, it should actually be the teaching support services. So we are going to be inserting...
What act are you reading?
A3 under the definition of teach.
A3?
The words teaching teaching support is supposed to be inserted between the and services.
Can you read the whole thing?
So it should read the teaching support services specified in the second schedule.
Okay, the teaching support services.
And not teacher support services. I think the second schedule currently has teacher support services. But as was discussed, we noted that those services are not teaching, not teacher support, but it's actually teaching support. So under the second schedule, teacher will be changed to teaching.
Madam Chair. Member Hamilton, does that answer the questions that you have?
Yes.
All right, good.
Madam Chair, just to help the committee, the next general comment is at the bottom of page 2. That one will be the mandatory licensing teachers already in the system. So we can just skip over the others because those would have been tied to other sections and we'll fix that. So the one at the bottom of page 2 is the next general. Look at the comment that the person is making. It wasn't tied to a specific clause. It was a general comment.
You're saying at the bottom of page 3? 2, sorry. Bottom of page 2.
That's not general, that is license.
No, you're talking about UTEC? UA?
No, UTEC.
UTEC.
But the UA one is also.
That's not general, that speaks to licensing. Madam Chair, the next general one in my mind would be on the bottom of page 3 under UA, School of Education. That would be the next general one.
This one that says the bill refers to sections
of the Education Act.
However, it was highlighted that the Education Act is under revision, and this meant that the references and sections were subject to change. This may have implications for the section of the bill that referred to the Education Act, given the imminent changes. Also, it says a major weakness in the bill is the limited attention given to early childhood education. I'd love to hear from us on that one. The bill did not seem to make a connection between teacher training, registration, and licensing, as such stakeholders considered the role that the teacher training institutions would play in aiding the JTC with registration and licensing. So if we can take those one by one. Huh? Oh, wow. Yeah.
That first one. Look at the bottom.
Well, on the first one, Ms. Sherlin, I'm sure, or no, Ms. Gordon-Jones, I'm sure you could answer. Yes, the Education Act is under revision, and I am sure that when that is completed, it will be aligned with this bill, but we can't wait for that revision to do this. Go ahead, Ms. Gordon-Jones.
So we envisage that this bill will be promulgated, and then the Education Act review will be guided by these provisions.
All right, thank you. So next week, the next time we meet, we'll pick up on this one, which doesn't seem so general at all. It seems to be linked as well to other clauses.
Criminal checks, though, is general. The criminal checks, Chair, on page 2 will be general underneath the University of the West Indies, I think.
Well,
who would cover the costs associated with criminal checks?
Sorry, if I may, Madam Chair, there is a section, the sections dealing with.
Can you go on your mic, Ms. Cunningham?
It's not working?
Oh.
Hello?
Yes.
Right, sections 35 to 38, there are discussions about payments of fees for the criminal checks, so we could defer. Yes. So we could defer that one to the discussion when we reach to 35 to 38.
Chair, apparently the reference to nurses and daycare centers has sparked interest of persons watching the proceedings. And so a question came in to me. Nurseries and daycare centers, is it that the ECC is going into communities, tracking down where there are nurses and daycares are? There are hundreds operating in the community space, from homes and where no signs are, and that would alert anyone to the fact that there's a daycare or a nursery. How would the ECC possibly be able to register these?
So the ECC registers currently, if you look at its database, over 3,000 of these institutions. There's a requirement in law for you to be registered if you are offering the service.
Oh, so that's the clarity. Where you have decided to operate and offer the service, you must submit for registration.
Yes, and then move on from that to licensing. So registration lets us know that you exist, and then you go into the licensing mode because there is, there are requirements for you to be licensed.
And it's not a situation, Chair, where like the bars and the pubs, I intend to apply for a spirit license.
Chair, I must admit that in my constituency, the ECC is very much present. They are very effective, and they find these institutions and they monitor them, because I have them coming to me asking for various things that the ECC is requiring them to have. So they're very effective, I must say.
All right, thank you, Member Hamilton.
Maybe the trick.
Okay. Go ahead.
I was just indicating that there is also a penalty under the Early Childhood Act for persons who are operating an early childhood institution without the proper registration.
Yes, absolutely. Right. They move to close them as well after a time. Yes. If they are not compliant. Yes. Yeah. All right. Members, I know we were told that at noon there will be another Joint Select Committee here, and so we have to vacate the Parliament. Thank you so much. There's obviously, you can see from the matrix in front of us, there is quite a bit of work to be done. We look forward to the kind of better grouping together of all these different recommendations so that we can move through in a more, in a way that will make better sense in terms of going from top to bottom. And as said earlier on, that we don't go around in circles, we don't repeat ourselves, and we don't circle back, but it is more streamlined. All right. Is there any other business? All right. The date of the next meeting is July 21st. At, what's the time? At 10 a.m., July 21st at 10 a.m. Oh, here it is, July 21st, 10. And if you want to put a future meeting in your calendar, it would be Thursday, July 28, 2022, also at 10 a.m. So I want to thank the members for showing up today to begin the deliberation of the matrix of submission. And again, I look forward to the next meeting and continue to implore you to be here early so that we can get through much of the discussion in the time allotted to us. Thank you, and ask for a member to move for the adjournment of the meeting. Moved by Member Hamilton. Thank you so much to all the members who joined online as well. Thank you for your input today. Thanks.
Here's how we sign the alphabet.